Hello, this is Attorney Bill Edgar, and I wanted to give you an update on the happenings in family law court and some of the issues that I've been seeing in the last couple of weeks with respect to custody, visitation, child support, and spousal support. Each court has handled this differently. For instance, Orange County Judge Hurwitz, the family law supervising judge, has stated, while schools are closed, parenting time shall continue as if the children are still attending school in accordance with the school calendar and relevant district. Spring break, summer break, vacation, or other designated holidays means they are regularly calendared breaks or holidays in the school district where the children are attending school. The closure for the school for public health purposes will not be considered an extension of any break, vacation, or holiday period or weekend. Follow the court's orders. If your child was on spring break last week, that should have been spring break, and therefore the court order would be followed. Judge Hurwitz goes on to say, denial of parenting time. COVID-19 is not a reason to deny parenting time. Unless otherwise ordered by the court, parents are considered fit to care for the children and make decisions regarding the day-to-day aspects of parenting while the children are in their care. The day-to-day care includes following all health authority and county public health directives regarding social distancing and sanitation-related measures, such as frequent hand washing. This is an important one, and I think one that I've gotten several questions on in the last couple of weeks. Supervised parenting time. All supervised visitation is to be conducted virtually via video conferencing or by telephone. Now, this applies to Orange County by Judge Hurwitz's orders. And I don't know if it applies to other counties, Riverside, San Bernardino. We haven't much guidance from the judicial officers, especially in family law. But that is an important question. Several other potential problems I would see is the supervisor being diligent themselves? Ask about what they're doing in regard to limiting the spread of this disease. Are they wearing masks? Any signs or symptoms of infection? And then obviously the other side, the other parent, are they having any signs or symptoms of an infection? Now that brings me to a question that's related, but not necessarily supervised visitation. Now, what if the other parent is a delivery driver? They work for Uber, they're a truck driver, or they work in the grocery store and they're out and considered an essential employee, allowing them to be out. This is where Judge Hurwitz's last order discusses transparency. He states, unless the parties are restrained from communicating, parents are encouraged to communicate about precautions they are taking to slow the spread of COVID-19. A parent is not permitted to deny parenting time based upon the other parent's unwillingness to discuss their precautionary measures taken or belief that the other parent's precautions are insufficient. That is a huge one. Lon Hurwitz, supervising judge in Orange County, has stated that specifically. In his email to us, he said all of the judicial officers in Orange County are on board with this. I suspect that all judicial officers sitting in family law courtrooms throughout Southern California will be on board with this. Riverside, San Bernardino, San Diego, Los Angeles included. Let me tell you what it says again. A parent is not permitted to deny parenting time based upon the other parent's unwillingness to discuss their precautionary measures taken or belief that the other parent's precautions are insufficient. So those are two important things coming from Judge Hurwitz in Orange County. San Diego County hasn't given us any specific mandates, and I'll discuss the court closure and processing of paperwork in a minute. The best one I think that we've gotten, we don't practice there, but the county of Napa also published a mandate and family law guidelines during this time. And in Napa, they say the same thing. COVID-19 is not a reason to deny parenting time. Unless otherwise ordered by the court, parents are considered fit to care for the children and make decisions regarding day-to-day aspects of the parenting. Exactly what Judge Hurwitz said in Orange County. Similarly, Napa has also defined spring break, summer break, as Judge Hurwitz did in Orange County. Parenting time in public places. This is from Napa. It may not be directly ordered in your jurisdiction, but I suspect that most judicial officers will have the same opinion. If parenting, strike that. If the parenting plan states the parenting time will occur in a public place, parenting time should continue at locations that are permitted under the health and safety guidelines for the state, such as a large park or nature hike. Public places where people routinely touch common contact surfaces such as parks and play equipment should be avoided. However, activities where parents and children can maintain social distancing and avoid such surfaces are encouraged. And where possible, parenting time should be conducted virtually via telephone conferences or video conferences. This is the Napa's guideline with respect to supervised parenting time. If parenting time is ordered to be supervised, the supervisor is unavailable due to COVID-19 related issues or government orders, the party should work collaboratively to ensure parenting time continues to occur in a manner that promotes the children's safety and well-being, such as finding an alternate supervisor. Again, telephone conferences or video conferences are encouraged. The governor has issued executive orders that restrict travel except for essential activities, which generally include caring for minors, dependents, and other family members. Again, I would stress that this does not give a custodial parent a get-out-of-jail-free card, so to speak, saying there's been a shelter-in-place order, there's a lockdown, and I'm not going outside because that's what the governor's orders state. This is not the intention. Oftentimes I tell clients there's the court order and there's the spirit of the court order. This would fall in the spirit of the court order. The exchange of your children is essential. You must comply with the court's orders unless there is medical conditions that would mitigate against that contact. Let me continue with the Napa guidelines. During the exchange of children, all parties should follow the CDC guidelines for limiting the spread of the virus, which may be choosing an alternative location for the exchanges that has fewer people congregating and less touching of public items. If you exchange at a Walmart or you exchange at a public place like a McDonald's, maybe choose a different place that has less people. Here's one I've heard several times from several different counties, several different judicial officers, and also the police dispatch. Stop calling law enforcement to tell on the other parent that they're not complying with the court's orders. They have more important things to do right now than come out and take a report. I know you all want to get that card and wave it around in front of the judicial officer saying, I made a police report and he wouldn't allow me to have the children or she wouldn't allow me to have the children. Just keep track of that. You don't need to call law enforcement to make a record of it. Contrary to what a lot of pro-pers think, police reports are hearsay. So unless you plan on calling that police officer to testify in court, just keep track and tell the judge the other parent withheld visitation for no legitimate reason and no medical reason, And as Judge Hurwitz said in Orange County, and I suspect most, if not all, judicial officers are going to be on board with frustration of visitation. So be mindful. If you frustrate visitation or you do not comply with the court's orders, and when this is done, the court's going to take that into consideration, and there may be substantial makeup time that is given to the other parent. And that's 7, 8, well, I've already discussed transparency. Talk to the other parent about what's happening in your family, who's exposed, if there are any signs of infection, and let them know if there are medical issues relating to the child. Again, schedule makeup time, video conferencing. There was one more thing. As Judge Hurwitz said, if someone wants to be hyper-technical about one of the court's orders in a crisis, our judicial officers will not be impressed or amused, and we will act accordingly. The entire bench is on board with this. If a party interferes with a court order or the intent, goal of such an order, again, the order and the spirit of the order, that conduct will be considered by the court on the issues of sanctions, attorney's fees requests, and future court orders regarding custody and visitation. As Judge Hurwitz also states, there will be a deluge of things happening in the future when all this gets sorted out and we finally get to a point to where we can have hearings again. So we discussed Orange County. They're probably the most specific with respect to providing us good guidelines to tell our clients. Also, the Association of Family Conciliation Courts and the American Academy of Matrimonial Lawyers have provided a joint statement of guidelines for separated parents during this crisis. Be honest about the seriousness of the pandemic, but maintain a calm attitude and convey to your children your belief that everything will return to normal soon. In my family, we're trying to avoid making careless comments in front of the children and exposing them to endless media coverage intended for adults. If you want to watch your favorite news channel, go in the other room. Your kids shouldn't hear this. Don't leave the news on 24/7, but at the same time, encourage your children to ask questions and answer questions and concerns that they may have. The AAML, American Academy of Matrimonial Lawyers, also suggests that you be compliant with court orders and custody agreements. As much as possible, try to avoid reinventing the wheel despite these unusual circumstances. A lot of jurisdictions, as I said, do have standing orders regarding breaks, school holidays, and also custody and visitation orders. They also encourage people to be creative and try to find alternative ways to allow the other parent to exercise their custodial time period. Again, they also encourage transparency. Be honest and provide the information to your co-parent about suspected or confirmed exposure to the virus, and try to agree on steps to limit the spread of the virus to either your family or the children. Be generous. Try to provide makeup time to the other parent who missed out. Family law judges, as I've expressed over and over, will expect reasonable accommodations when they can be made and will take seriously concerns raised later in filings about the parent's unwillingness to comply with those court's orders. And I'll go through some of those in a minute. So I had a conversation with a potential client on the phone, and she says, I have sole legal custody and he's not getting visitation. I asked why. There was no reason why. It was just because she had sole legal custody and she was relying on Governor Newsom's shelter-in-place order and she wasn't going out. Every judge that I've heard from is going to say that is not the course of action that you want to take. That is not an unreasonable position to take, and the judges are all on board with that. Clearly, I cannot cover all potential issues in this general message, and each situation must be handled on a case-by-case basis. So I've also had, well, the other parent is a delivery driver, or they work at a grocery store. Well, if we're going to have that argument, then what about nurses, doctors, police officers, firefighters? This is where that transparency comes into play. Talk to your other parent. Unless there's a restraining order, you must talk to the other parent and be creative and be generous and be reasonable. Again, I would think that all judicial officers will agree that a child custody exchange isn't an essential function, that you should be out exchanging the children unless there's no issues of compromised health. Now, I've also had issues where there was a discussion about a child's compromised health. It has to be present right now. We're not talking about a lung infection the child had at birth 13 years ago or 9 years ago that has never had any complications since. If you have a concern, ask the child's doctor if they should be doing custody and visitation exchanges. Get a note, because if I'm on the other side of that case and it goes to court and we believe that you've withheld visitation unnecessarily or unreasonably, I'm going to ask for that. Again, calling law enforcement should be extremely limited, if not done at all. Now, there's another issue that I'd like to raise about child support, spousal support, that has some significant consequences because of the court's closures. I'd tell you that most of the courts are now closed to April 30th. Riverside is closed to the end of April. We haven't heard from San Bernardino, but the people I speak to there say that it most likely will be closed until the end of April. And I'm discussing family law cases here. I'm not talking about criminal cases or any other aspects. I'm talking about family law cases only. Orange County is also closed to June. And San Diego County is closed to the end of the month of April. What a lot of counties have done is they've declared these days as court holidays, meaning if you file a document today, it will not be stamped or filed until this is over with. So we are having, as attorneys, we are having issues with retroactivity of any issues with respect to support. Typically, if you file a request for order, you will have retroactivity back to the date of filing. But if the court declares these court holidays, that may not happen. I suspect, as do many judicial officers, Judge Hurwitz from Orange County included, that there will be some make-up rules or subsequent orders from the Chief Justice with respect to this retroactivity issue. My practice right now is if we file an RFO, it may not be filed until May or June, depending on the specific county. I think it's best practice to put the other side on notice, again, that transparency issue, that, hey, I have been affected by the COVID-19 furloughs or layoffs, and my pay has been drastically affected. Here's my paycheck stubs. Here are my unemployment proof of income. These things need to be sent to the other side to at least give them notice that you intend to ask for relief from a child supporter or spousal supporter somewhere down the road, like when we can actually address the court. I think those will have make-up rules and make-up laws as we go. So if you are affected by those financial issues, we are open. My information is here on the screen. However, we are not going to have access to the courts for at least April, if not through May. So I've encouraged a lot of attorneys to let's sit down and try to settle the cases. We could have video conferences and Zoom meetings where we can try to settle the cases. Judge Hurwitz and others have strongly encouraged parties to try to settle their case, especially in this time of crisis where we can try to bring people together as much as we can. My office is going to start doing mediations or private judging, and if you have one of those issues and you can't get you can't settle a case where there's a custody visitation issue and you don't know what to do, we can assist the parties in reaching a resolution, whether it be custody, visitation, child and spousal support. I have also encouraged in Riverside, typically, that there are 7 or 8 senior level attorneys that have been doing this longer than 20 years, and we're going to hopefully start doing some private judging and move some of our cases along if we can't have access until June. Clearly the parties will have to agree to allowing a private judge or a mediator to make a decision on a case, but that's something that I call a band-aid that we can get us through April and potentially May until we're able to get back into court. We need to be creative as lawyers. We need to be creative as self-represented people in a way to try to get these cases resolved as expeditiously as possible and keep everyone safe, themselves, the children, and the other side. So hopefully this addresses some of the issues and concerns that I've seen in the last 2 or 3 weeks. It's an update on the court's closures. If you have any comments, questions, or concerns, I have left my email address there. You can also send me an email there. Hopefully this ends quicker than the end of April. I suspect it may not, so we need to take all necessary steps to move cases forward. Thanks.